Thank you, Ms. Ways, for your question. The application 181921 CLE, which is storage in the land adjacent to the Reviva waste site, was an application for a certificate of lawfulness for an existing use. The refusal of the certificate on the 26th of November 2018 confirmed that in the Council's view, the use was not lawful in planning terms. In reaching this decision, the local planning authority, Hertsmere, did not reach a view as to whether the use might be acceptable in planning terms, and the decision in itself did not place a requirement on the applicant to cease the use. While we would hope that the landowner would remove any unlawful use of their own volition, this has not occurred, and the Council is now considering whether formal enforcement action is expedient in this case. Sadly, planning enforcement is a slow process with rights of appeal, and the Council cannot at this stage make any commitment to a particular course of action.
Councillor Cohen, previous to the application on the land adjacent to Reviva for waste storage, number 18/1921/CLE, there was a previous planning application on the same land, and this one was also for waste storage. Planning application number 18/1065/CLE. The latter was also refused, and that happened on the 20th of July 2018. But as we know, there is still waste stored there. Could you let us know why enforcement did not take place on that occasion too, and when enforcement on that land will finally take place?
When the Council consider going for enforcement, there's many aspects they have to take into account, because there's many legal issues about it. And they have to be absolutely certain that it is a case of last resort before they do it. The Council are now considering that, as I said. They haven't reached the decision. They're in discussions with the applicant about it, and a decision will be made soon about the enforcement. But the enforcement officers are on the case and are discussing it and looking into it at the moment.